federal statute 18 USC 241 and 242 have been discussed quite a bit in the context of the Second Amendment, whether or not we can hold anti-gun politicians liable under the criminal statutes of America for violating our Second Amendment rights. Stay tuned. We'll talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks. I get this comment quite a bit on Twitter and other social media accounts. And by the way, for those of you who are not following me on Twitter, to the extent you're on Twitter, you should definitely check me out at Four Boxes Diner, because even though I've only been on there for about 6 months, I am adding thousands of followers, and I'm trying to get more information out about the Second Amendment to that community in addition to the YouTube community and beyond, because I think it's so important that we educate the Second Amendment community as much as possible about these issues and what's going on with our rights. Okay, now, one of the questions I keep getting and comments I keep getting is whether or not we can hold anti-gun politicians that vote to take away our rights or work to take away our rights. Can we put them in jail under two federal criminal statutes, Title 18 USC 241 and Title 18 USC 242. Just to jog your memories, if you're not familiar with these, you should be, by way of background. Under Section 241, conspiracy against rights, the relevant federal criminal statute says that if two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, and so on, in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or the laws of the United States, shall have committed a major crime. I won't bore you with the details of the prison sentence, but it can be up to 10 years. Now, under federal criminal statute 18 USC 242, deprivation of rights under color of law, that statute under the federal code says, whoever under color of any law, statute, or ordinance, regulation, or custom willfully subjects any person to any in any state, territory, commonwealth, and so on, to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, then they shall be fined or imprisoned by more than a year, and so on and so on. So the point is, 18 USC 241 and 242, the two federal statutes, are criminal statutes. Now, a lot of people have said, can we use these against the anti-gunners, the anti-gun politicians, among others? And the answer is, unfortunately, no, we cannot. The reason why we can't do it is threefold. Number one is the standard that has been set by the United States Supreme Court to be found guilty under either 18 USC 241 or 242 is very high, meaning it's very difficult to convict someone under these criminal statutes. This is not my opinion. This is not like what I want, by the way. I just want you to be aware of this, because I don't want you in the Second Amendment community to spin your wheels and go down rabbit holes that are unproductive. It's not that I don't like these ideas of going after the anti-gunners with these criminal statutes and the like. It's just, I don't think it's fruitful, because the courts have been so clear across the board for the last many decades that it's just not viable for various reasons, and I want to go through them right here and right now. First of all, as I mentioned before, it's a very high standard. Specifically, the Supreme Court has held in relevant part that a violation of Section 242 and, of course, 241 occurs when government officials act with actual perceived or pretended authority of the law, meaning they're acting under the guise of law, like they're politicians, they're cops, whatever it is, they're town clerks. They're acting within the scope of the authority of the government, meaning they're acting as state actors. And they do so, quote, in open defiance or in reckless disregard of a constitutional requirement which has been made specific and definite. And I think those are key words, specific and definite. And what I mean by this is, when it comes to our Second Amendment rights, although our arguments are really the better arguments, our theories are definitely the better theories when it comes to the meaning of the Second Amendment, the reality is there's still enough wiggle room out there in the law that the anti-gunners and these politicians say, look, we think we're acting within the scope of the Second Amendment. We think that this is allowed because the Supreme Court has said that some regulations of firearms are allowed. We're engaged in some regulations of firearms, so we think we're doing the right thing. And because some of the things they're doing, there's not what I would call a specific, indefinite, clear holding that says you can't do that. I think there's enough wiggle room to get around that very high standard if you're an anti-gunner. I think that what the court's talking about when they say definite and specific, and I'm not sure this would even work, but for the sake of argument, I think if you have a specific court order that tells you as a state actor that what you are doing is illegal, what you are doing violates the Second Amendment, what you are doing violates the First, whatever it is, and you still go ahead and do it, then I think maybe you could be subject to a criminal charge. The example I like to give is if you're a town clerk and you've been told by a court that you have to honor the quote-unquote constitutional right of gay marriage, and you refuse to issue a license to a gay couple to get married, even though a court order has told you that it's constitutional, they have a constitutional right to the marriage license, you have to give it to them, and then you choose not to. I think that might be the sort of thing that could get someone in trouble under the criminal laws of 18 U.S.C. 241 and 242. Historically, though, where you really see these kinds of charges is in the context of police officers doing bad things. Specifically, for example, Derek Chauvin, who is the guy who was on the neck of George Floyd in Minneapolis, that he was convicted. I think he pled guilty after he lost in the state court case. He pled guilty to violating 18 U.S.C. 242, 241, of George Floyd. So that's the kind of thing that is the very heavy burden, and that is viewed as, in that context, kind of a violation of not just the Fourth Amendment's unreasonable search and seizure and the freedom associated with it, but also arguably the Eighth Amendment against cruel and unusual punishments by the state. So again, that's the sort of thing that we're talking about, some very high standard that's definitely, and most of the time these are get used against police officers, is the harsh reality of this law. The second thing I want to note, of course, is that these are criminal statutes, which means they're federal criminal statutes, which means that the person responsible for going after someone criminally would be the Attorney General of the United States, in this case today at least, Merrick Garland. So the odds of Merrick Garland as the Attorney General of the United States going after anyone using this federal statute because they violate someone's Second Amendment rights, I would say, is between slim and none. That's just the harsh reality, but I don't think he views anything going on with gun control to be unconstitutional in his view. I think he basically is always going to defer that gun control is legal and constitutional under the Second Amendment until basically forced against that view by a specific U.S. Supreme Court decision. I think that's the harsh reality of it, where you have Merrick Garland as your Attorney General of the United States. And last but not least, no, you cannot sue under 18 U.S.C. 241 or 242. These are federal criminal statutes. You can only potentially go to jail if you violate them. You can't be sued. I mean, I can't sue someone for money damages or in a civil court for violating my Second Amendment rights or any constitutional rights, because both 18 U.S.C. 241 and 242 are criminal statutes. It's been repeatedly said there is no private cause of action. I'm just going to give you an example here from just this week. There was a case, there's tons of these cases out there, which is, again, I'm sympathetic to the view of using this to protect our Second Amendment rights, but the harsh reality is there's just too much case law out there against us on this particular point, and we'd be better off focusing our energies on other ways of protecting our Second Amendment rights. But specifically, here's a case that was just decided called Bay, B-E-Y, Bay versus Sessler in the Northern District of Ohio. And in that case, the federal district court judge, just like in the last week or two, dismissed all lawsuits and causes of action that were brought by the plaintiff in that case under sections 241 and 242. Specifically, what the judge there said is that, quote, a private citizen has no authority to initiate a federal criminal prosecution. A private citizen lacks standing to initiate criminal proceedings. The judge cites to a bunch of laws. And then he goes on to say, quote, moreover, these statutes do not provide a private right of action in a civil case, period, close quote. And then the judge cites to a whole host of cases that support that proposition. So it's pretty clear that we can't sue under 18 U.S.C. 241 or 242, nor can we control a criminal prosecution under 18 U.S.C. 241 or 242. That right now is in the hands of Merrick Garland. And even if someone could charge someone for violating the Second Amendment right to keep and bear arms under it's very unclear to me that any of those would survive a motion to dismiss in the criminal context, because you really have to demonstrate that someone is, quote, in open defiance or reckless disregard of a constitutional requirement which has been made definite and specific and definite. And I think that there's enough wiggle room in the context of Second Amendment litigation right now for the gun controllers to at least avoid going to prison for violating these statutes. Okay, folks, I appreciate these ideas and keep them coming. Don't be discouraged just because something doesn't work out. There's a lot of ways to skin a cat, as they say. So let's keep on fighting for our Second Amendment rights, even though I don't think this is a fruitful way of doing it right now. There's other ways we can do it. So let's keep going down the paths that I think will bear the most fruit. And again, if you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.